All right, welcome back to Law&Crime Network. We are covering the Ashley MacArthur case out of Florida. It's already fascinating with a lot of twists and turns. I've been in studio with Katie Smith, but then I also have the opportunity to bring in one of our favorites here at the Law&Crime Network. I've had on many times, Latonia Hines, prosecutor, Emmy Award-winning TV legal analyst. Now, I've not read that title with anybody else, and the one that I like the most is a self-professed hardcore Gator fan. How you doing, Latonia?
I'm very well indeed. My team won this past weekend, so it's great.
Well, they got you cheering for them, so they got a great advocate. For sure. So what do you, let me just toss it to you. What are you thinking of this crazy mishmash of a case here with all these personalities and this money going around? How's the prosecution doing putting this case together?
Well, I mean, they're trying, and the main thing is you've got to really lay it out for the jury so they get it and they understand it. It's already hard enough understanding racketeering on its own, but understanding the nuances with regard to what MacArthur was doing and then her motive for wanting to kill the victim. And so that's where we've got to make sure that everything's clear. So they're going to be painstaking about it.
Yeah, for sure. And I'm being told by our producers that there's more court activity, so let's go to court. Okay, while we're waiting for that next witness, Katie, I think that obviously the point that was trying to be made, I love when recrosses, they start getting more and more narrow, is did he tell you to get rid of this 38? What is the idea there is that is the murder weapon, and the answer was no. He just gave to me that gun like many other guns. That was a good testimony for the defense, and you had indicated when we were off camera that it almost seems like the defense had opportunities to prep this witness even though it was a prosecution witness. What did you mean by that?
Well, I think that at every opportunity, they were trying to get more favorable testimony from him. You know, have you ever seen her angry? Did she ever have you get rid of the gun? You know, painting this picture that she was relatively charitable. It seems to me that he obviously does not want to be there testifying against his ex-girlfriend, and I felt that it was smooth enough that it looked like the defense probably had the opportunity to talk to him. Yeah,
Latonia, what do you think about all that?
Because normally when you have a witness called by the prosecution, it doesn't feel like you're pulling teeth, and somewhat it was kind of pulling teeth. He didn't give you anything more than yes or no, and I definitely felt that he had been prepped by the defense.
Yeah, interesting. So sometimes prosecution puts on somebody that maybe I was very, very, very reticent to doing that when I was a prosecutor for that exact reason. Anyway, Alexis Cook, I believe, is on the witness stand. Let's go to court. Okay, well, the most important question of every trial, and it's in every single state, is what about lunch? Okay, everything revolves around the lunch schedule and making sure the jurors are well fed. I've got another in-studio guest with me right now. It's a great honor again to have Kurt Burkhalter with me. As a professor at NY Law, 20 years with the New York City Police Department, detective first grade, did long-term investigations, organized crime, domestic and industrial terrorism, and a great guest here at the Law&Crime Network. Welcome back.
Thank you, my pleasure.
Okay, so since you're the newest one, so you know, what are you thinking right now? I mean, I think when the prosecutor on redirect, and I did it many years myself, has to come back and say, are you a really nervous person and that's why you make mistakes when you testify? It's really not like the best thing. It's a good question to ask, but that's basically saying you recognized mistakes were made in the testimony.
I agree. Yes, it's in a perfect world, it's not a question you want to ask, but certainly the defendant was nervous, the defendant made mistakes, and if the prosecutor had the choice between hiding those mistakes or putting them out in the open for the jury and helping them make a decision, I would go with the latter, right? You're nervous today, aren't you? Do you know, isn't that you're testifying at a homicide trial? You're testifying about drugs and so forth. Wouldn't a normal person be nervous? So it does help to humanize the witness. How much damage control is up to the jury.
Interesting, though, how prosecutors don't feel the same way when the defendant is on the witness stand and making some, you know, mistakes. And those are the people who ultimately are nervous because their lives are on the line. Quick, 10 seconds or less, each one of you. Katie, did this witness go well for the prosecution or not?
I think it went better for the defense.
Better for the defense?
The defense, correct.
Professor?
Anytime the defense can show that there are errors in testimony, it's better for the defense.
Latonia?
I'm going to have to say defense.
Yeah, okay, and I happen to agree. This was not a witness that killed it for the prosecution, and you got to be careful with that. You have to make sure your witnesses are going to be pristine. This wasn't one of them. This is going to be a fascinating case, folks. Only in the Law&Crime Network, gavel to gavel coverage. We'll be back with all these great guests. Stick with us. We'll be right back. Okay, completion of another prosecution witness, a friend of the defendant. Latonia, let me go out, since you're not in studio and you're listening to this. I'm asking, what was the value of this witness to the prosecution? How was this moving the prosecution's case forward? Did it succeed, and how did the defense do? It's a big order, Latonia, but I know you can handle it.
Oh my gosh, that's so much. First of all, the value of it is that I guess on some levels it bolsters the conversation that was had with the other witness that we heard earlier, the one, I don't know what to call her name, the defense got out Grand Theft Auto. So that's all that's sticking in my head right now. The other benefit from her is this whole idea about the cocaine, the fact that it wasn't in the media, and then two, that she was a closer friend than the other person who was mentioned earlier. So you've got a better connection there with regard to that conversation. And also you have an idea into what is the mindset of the defendant. What is it that they normally do together? So you've got some of that. Is it the strongest thing? No, not necessarily. That's the thing I'm gonna have to say about most of these witnesses. No one wants to be here. And most of the time, nobody wants to testify in this type of trial, but you really get the impression these people do not want to be here, especially because you're now airing out their own behavior, the own things that they've been doing. So I see why the prosecution's doing it, to get things to go forward, inch by inch, but it's not an attractive inch by inch.
Yeah, and Professor, I used to watch people armchair quarterback the cases that I was trying, and why do you put that witness on when I've got 14 other witnesses that I'm going to be putting on, and each one has a strategic reason, at least I hope that it did, as to why it was being done. So sometimes a little unfair to question why the prosecution is doing what they're doing right now. But they're not home run witnesses, and I'm wondering whether sometimes you can put on enough of these kind of people where the jury starts to lose, their sensibility about, well, what are we doing here? We're losing focus. And I've seen some lawyers do that. There used to be a theory for some people in my office used to say, just throw everything up against the wall and see what sticks. Yours truly was never a fan of that philosophy. What are your thoughts?
Well, I agree. Never just throw everything against the wall, because it tends to confuse, confound, and even bore the jury, possibly. However, as we mentioned, the previous witness wasn't as strong. So if you can get to find a happy medium, where if you have a few witnesses that are not strong, in the aggregate, they may be a little bit stronger. But the problem is, once you put up a succession of witness after witness after witness that is not strong, then it starts to smell like your case is not that strong. So I do think that this last witness moved the needle forward a little bit. However, I agree with Latonia that these folks they're younger. They definitely don't want to be there. Exposes their dirty laundry. They're being asked about drinking and so forth. And it's always in the back of the jury's mind when someone admits that they have been drinking, how reliable is their memory.
Right. Katie, before with one of the other witnesses, a colloquy occurred, or a question kind of came out there, instituted by the prosecution. The witness answered in a very bad way, and the judge basically admonished and stopped it. Can you give our audience an explanation of what went on there? And then I'd like to talk to you about what would your experience. In mine, there'd be a curative instruction very strongly given, and as a defense lawyer, I would have been up there yelling and screaming that this information was allowed to get out, and I would have been looking for a mistrial. Thoughts?
Agreed. I think we both cringed when we heard this. It was surrounding questioning. I think it was Alexis Cook. The prosecutors are questioning Alexis about what she had perceived in the media. And one of the statements was that Jessica, her friend, had stated that the defendant killed the victim. And we both were like, ugh, because that's bad. That should never come out. There should have been an immediate curative instruction, and I would have moved for an immediate mistrial. The only reason not to do that is to highlight, you don't want to shine a spotlight on something that's negative if it could be easily glossed over, but that's a biggie.
Yeah, and in our jurisdictions, at least, and everyone's a little bit different, the judge is required, is mandated to give a timely and forceful curative instruction at the time, the compounding argument they really don't follow. And that is one where the prosecution could have gotten hit with a purposeful attempt to derail the case. And mistrial could have resulted in a double jeopardy issue there.
Exactly, because before these things go, there's always going to be motions in limine. The judge is always going to explain the parameters of what information can come out. That should never have come out, and I felt like the prosecution wasn't controlling it enough.
Right, right. Okay, excellent analysis, boy. I got one heck of a panel of guests here today at the Law and Crime Network. We're going to do a little business. We're going to go to a commercial, but I'll be back with all these great folks and this fascinating trial. Don't go anywhere.